Thank you very much, Sarah, and welcome to everyone. 4 weeks ago today, I spoke to the status of the draft protocol for remote questioning. And at that time, that afternoon, in fact, it was being finalized and it was being presented as a draft to our Court of Queen's Bench of Alberta for their consideration. That was in advance of a conference call that had been scheduled with the Chief Justice of our Court of Queen's Bench and other members of the Civil Bar, which was to occur on May 7th, the following week. So in advance of that call, I had reported to this group and other members of this audience that we had finalized a draft to put before the court. Some of you may recall that where we were at on April 30th was that we had prepared the draft in response to an invitation by the court following an emerging theme of concern at the bar or by the bar that litigation proceed and that the questioning proceed in such a way during the pandemic that would serve purposes of all parties. So as a result of that emerging theme, we were invited by the Court of Queen's Bench to develop, to work together as a bar and develop the protocol. The draft protocol was then presented to the court. The court responded very promptly, thanking the working group for its work on the protocol, confirming that the court does not have the authority to endorse any specific protocol or set of practices, but they did have a recommendation if we were so inclined to consider it, and that was being advanced by the Civil Law Steering Committee co-chairs, who described the protocol to be reasonable and workable. They made two comments, one which I'll speak to once I speak to the protocol, and the other in terms of the court reporter's role in all of it. And again, I'll speak to that when I get to the protocol. So essentially what happened after the Court of Queen's Bench made their submissions, or excuse me, provided their response, the protocol was then finalized, and it presented itself and is now being referred to as the Alberta Protocol for Remote Questioning. It has been circulated widely by our own association, by the CBA. It may or may not be on the Law Society website. I'm not aware of that just yet, but nonetheless, the questioning protocol is a 7-page document to which there is a preface prepared by Grant Watson, who was our leader, and an attached appendix. I say that because the current protocol is listed as pages 1 through 8. That includes the preface, so there's only 7 pages to the protocol, which includes the appendix. With respect to the protocol, I'll just briefly make some highlighted comments. It's been attached as part of today's materials. I don't propose to review it. You're all more than capable of reviewing the protocol yourself, and I understand many people have already been practicing questioning by remote quite frequently now, so it's almost becoming an old document, if you will. So the protocol is essentially set out where we've attached or we've spoken to steps that must be taken prior to the questioning, of course. Maybe just before I get there, I'll just maybe point out some things out of the purpose and objectives, and that is that the protocol is meant to address other challenges, not just questioning. And of course, many of our colleagues will have been using forms of the protocol in other scenarios well in advance of the pandemic. So we certainly don't suggest that this is a document that wasn't already in force, or the practices behind the document wasn't already in force. So the purpose of the protocol was to assist our colleagues to make a document that was consistent for users, to simplify procedures for people who may be coming to it for the first time, and simply to provide some consistency that for the benefit of all parties, knowing that the protocol is a document that's been widely commented upon and is a solid and reasonable piece to work with. So essentially the purpose of the protocol is not intended to supersede any rule, right, obligation, or procedure set out in the rules of court or in the Law Society Code of Conduct, except where a variation, which is not inconsistent with those documents, is agreed to by consent of all parties. And that's an important point of the protocol. We also want to make it very clear that the protocol is simply a manner in which to conduct the question, but it doesn't take away from anything that would normally be expected in a normal questioning, where all parties are present and you know, sitting across the table from one another. With respect to the protocol itself, regarding steps that you would take prior to questioning, of course, you will have all been on other webinars of this nature, so you will know that we are encouraging you to address the selection of the technology platform, scheduling and equipment and setting in advance of the actual questioning or event itself. With respect to the records, this is where I'll just pause and just speak briefly to the recommendation brought to our attention by Chief Justice Morrow on behalf of the Civil Law Steering Committee. And that was at the point of records on page 4, as it currently shows up on page 4 of the document. They were just suggesting some wording to ensure consistency with respect to ensuring the authenticity of documents and their admissibility around, to be consistent with Rule 5.15. So the current form of the protocol indicates, or I should say reflects, that recommendation to the extent that we were able. Secondly, the court encouraged us to leave to the parties their decision, any decisions that would be made with respect to how the court reporters may or may choose to be involved in terms of whether they will host the questioning in addition to their other responsibilities. But other than that, as I say, the court, without endorsing the policy, the protocol, they described it to be a reasonable document. With respect to the remainder of the questioning protocol now, I'll just carry on with some general comments. Our experience, generally what we're hearing is that testing, the meeting, of course, in advance as well, recommended. The questioning protocol encourages us to behave and conduct ourselves and encourage our clients, of course, to behave and conduct themselves in the same manner as if they were in a questioning proper in a physical setting. And that, of course, includes the application of conduct money. When we last discussed the protocol, a few questions arose as a result of conduct money, etc. And just to reassure people, conduct money would be recommended and, of course, required in the same sense as if you were to require the conduct and pay for that conduct of a party. Where you might not have to deal with that is if a witness is in the comfort of his or her own home. Perhaps travel monies may not be required, but you might have to address other components of the conduct money rule. For an example, if a party were required to attend at the location of a court reporter or at an office because they don't have the personal equipment at home to deal with, a virtual questioning, then that expense may or may not be required. But of course, ultimately, conduct money would be a requirement, whether or not it should be addressed, I should say, whether or not questioning is remote or in physical, if you're physically across the table from the person questioning or being questioned. Again, the adoption of the protocol has to be by agreement. The oath and affirmation and undertakings remains the same. And we've accounted for the swearing or being the affirmation or oath taken by a witness can be provided for by virtue of the Scottish oath, which is provided for under Section 16 of the Alberta Evidence Act. And rules of admissibility and evidence are the same. Nothing will change there at all. One of the comments that I do want to point to, and just to bring to everybody's attention, the Appendix A is a set of preliminary questions which we envisioned would be put to witnesses and agreed to by all parties in advance. And that, of course, includes the agreement to not record or rebroadcast the questioning. And while we had some discussion about whether we should actually have witnesses, non-lawyers, sign that document as they were doing with the courts, we determined that it would be sufficient to simply agree to the questions by virtue of what's set out in the Appendix A and have people commit to those. So other than that, the protocol is final. I want to just take a moment to acknowledge again the work of my colleagues on the protocol, Sam Leung, Ola Malik, Patrick Heinzen, Donna Purcell, Julia Ebenescu, excuse me, and most importantly, Grant Watson. You'll also note at the preface, Grant has offered to be the point person for suggestions for future revisions. We recognized very early on, with the great interest that many parties had with respect to the protocol and the wording, that it was a document of great interest to many of our colleagues, ourselves, and therefore we consider it to be a living document. So thank you to my colleagues and to Grant in particular, who's leading the charge to be the point person for future revisions. And finally, if I may, I just want to acknowledge the tremendous amount of work that was started with these webinars. I want to pay particular attention and give kudos to Donna Purcell, who is a member of our board, whose idea was these webinars, to Jillian Gamez, Sarah Coder, our staff at ACTLA, and all the presenters and various participants who have made these webinars so successful. By now, you'll have all had tremendous exposure to conduct of all kinds by virtual methods. And so what I've shared with you today may not be anything new, but we do encourage you to revisit the protocol, to use the protocol, and good luck to all of you in your use as we move through further changes with this pandemic. So thank you very much.